Good morning, everyone. And as Lola, thank you very much for your introduction. I don't know where you were, there you were. My name is Isabelle, and I am with the Ontario Ministry of the Attorney General. And I'm going to be speaking with you today about the Attorney General's work on developing the court interpreter program in order to ultimately ensure that charter rights are protected for the people of Ontario. And I guess before I go into my presentation, I'll just say a few words about myself. As Lola mentioned, I've been with the ministry for 12 years, and I've been specifically with the court interpretation unit. So I've been with that program for my entire time with the ministry. I've had a number of different roles. My current role is as Interpreter Quality Assurance Coordinator. And there's actually two of us in the province that are in that role. There's myself and my colleague, Stephen Turing. So together, we test interpreters, we train interpreters, we do a lot of support for court staff with interpreter program issues, and we do a lot of support with our interpreters directly as well. And that's kind of a small part of what we do. A large part of what we do as well is a lot of policy and program development for the program. I have to apologize as well because I'm dealing with a bit of a head cold, so I apologize if I break out into a little bit of a coughing fit. I want to say that I feel very honored to be here today, and I do see a number of familiar faces in the crowd and in the room, and I've had the great pleasure of meeting some of you through testing and training with the ministry. Okay, so today I'm going to be talking about the Ministry of the Attorney General's role in ensuring access to justice through the provision of qualified interpreters for the courts of Ontario. Okay, so Ontario is one of the largest jurisdictions in North America. Excuse me. So this graphic here shows you how Ontario is one of the largest jurisdictions. There are 3 levels of court in Ontario. So we have our 2 trial courts. There's the Ontario Court of Justice and Superior Court of Justice. Okay, then on top of that is the Ontario Court of Appeal. There are over 300 court sites in the province. So this includes both the ministry courts as well as the municipal courts. And as our court interpreters know, municipal courts, they deal largely with traffic infractions, the Provincial Offences Act. And these 300 courts, they encompass over 700 courtrooms. The Ministry of the Attorney General's mandate is to provide modern and professional court services that support accessible, fair, timely, and effective justice services. Court interpretation is a part of the Ministry's core services. With Ontario's diverse population, language interpretation services, as you can imagine, are in high demand. Okay, so each year there are more than 150,000 hours of interpretation that are provided in the courts of Ontario, okay, in over the 300 municipal and provincial court sites across the province. So Ontario, in addition to being one of the busiest jurisdictions in North America, we also have very unique requirements as listed here. So high volume urban centers. Ontario has the most culturally diverse population in Canada. According to a 2011 census from Statistics Canada, Ontario is one of the 2 provinces with the largest population of people born outside of Canada. So British Columbia is the second, as being the other province. In 2011, there were approximately 3.6 million immigrants living in Ontario. Many have been living here for a number of years already, while others are relative newcomers. In terms of urban centers, here in Toronto, there were approximately 2.5 million immigrants according to 2011 data. That accounts for 46% of Toronto's population. That's huge. That's a very high number. Out of nearly 37,000 bookings for interpreting assignments in Ontario's courts between 2015 and 2016, about 41% of them were held here in Toronto alone. So that's almost half of the bookings for court interpretation assignments in Ontario are held in Toronto. The Central West region, which includes Brampton and Hamilton, they are next with about 32% of the bookings. Remote northern communities. So as of 2011, there were over 300,000 Indigenous people living in Ontario. So Indigenous, these are the First Nations, the Métis, and the Inuit people. Ontario has the largest number of Indigenous inhabitants in Canada, and it also has the largest First Nations population in Canada. The majority of these First Nations people live in the northern parts of Ontario, with the majority of those even living in very remote communities that are accessed only by plane. So you can imagine the intricacies involved with planning a court proceeding in what we call as a fly-in court. So court parties such as the Crown, Defense Counsel, court clerk, the interpreter, even the judge, they're all flown in on the same plane, usually a really small plane to these remote locations. Provision of court services in French. So English and French are the official languages of the courts in Ontario. There are several pieces of legislation that form the legal framework establishing Francophones' rights in Ontario, as well as the Ontario government's obligations in the justice sector. So examples of legislation are the Courts of Justice Act and the French Language Services Act. As you will see in a moment, one of the Ministry of the Attorney General's mandatory requirements is of providing French interpreters when one is requested by the party or witness. And then finally, the last point is the trend towards complex trials that attract media attention. So this is self-explanatory. We read in the newspapers all the time, more often than we'd like, about trials of horrific crimes, perhaps with multiple accused, many witnesses that can go on for months and months. So the media loves to report on crime and court matters. The ministry is accountable to the people of Ontario, and the media, as part of its role, certainly helps to ensure that this accountability is met. Excuse me. Okay, so this next slide is about a section of the Canadian Charter of Rights and Freedoms that forms the basis, the foundation for which my unit works on, the Court Interpretation Unit. So the Charter was enacted in the Constitution Act of 1982. Section 14 is specifically under the legal rights section of the Charter. Okay, so it is specific to court proceedings. So Section 14 states that a party or witness in any proceedings who does not understand or speak the language in which the proceedings are conducted, or who is deaf, has the right to the assistance of an interpreter. This section protects a person's right as a member of Canadian society, ensuring that the individual can participate fully in the legal process. This right ensures that the party, so the accused, is deemed fully present in their own court proceeding. This right applies regardless of which language is involved. This applies for any criminal proceeding, that an interpreter is always provided when a request is made for one. The Supreme Court of Canada has said this right also has a basis in Canada's multiculturalism. As an aside, Canada's multicultural heritage is actually officially recognized in Section 27 of the Charter. So it is because of this Section 14 that the ministry places a high standard and expectation of its own interpreters. Interpreter testing, therefore, is of a high standard. Training is of a high standard. We are held accountable to ensure that this inherent right of Canadian citizen, as outlined in the Charter, is not violated. So this is now talking about the Ministry's provision of court interpretation services for Ontario. So we will provide any interpreter, provide and pay for an interpreter for any language when it's required in criminal and child protection matters. Excuse me. For any language in civil, family, and small claims court matters if the litigant qualifies for a fee waiver. So a fee waiver, the litigant would have to apply at the court counter. The application form, they have to state their financial information. It's based on this information that a determination is made. They're deemed qualified or not. If they're not qualified, then they have to be provided and paid for their own interpreter. For French, in all civil, family, and small claims court matters. Okay, so for French, we will provide for any and all court matters, for all criminal, civil, small claims, and family. In addition to this provision, anyone can request a French trial for a criminal matter and a French or bilingual trial in civil and family cases. Just to note that this is different from an individual requesting a French interpreter. So in a French trial, the judge and prosecutor would speak French. Likewise, for a bilingual trial, the judge and prosecutor, even the clerk and the reporter, they're bilingual. Okay. The next point is American Sign Language, ASL, and Langue des Signes Québécois, LSQ. That is provided for all court matters. Okay. In addition to that are other visual language interpretation services, such as deaf interpreting and the use of CART. CART stands for Communication Access Real-Time Translation. Okay, and I will be speaking further to this point later in my presentation. Oops, not yet. And ultimately, last but not least, is we will provide an interpreter for any language when it is ordered by the court. So it could be that an individual goes to court, they don't know what their right is, maybe they think they can manage the language, so the judge would deem, they make the call, actually they think that the individual does need an interpreter for the court. So if that's the case, then it's deemed that it's a court-ordered request, and we never question that, then we would provide an interpreter. Okay. Sorry. So my unit, the Court Interpretation Unit, is part of the Court Services Division of the Ministry of the Attorney General. It oversees a number of primary functions of the Court Interpretation Program in Ontario. I already mentioned that there's two of us on the team, myself and Stephen Truong. There's a third member, her name is Lily Dang. She looks after the interpreter's registry. And that's it. There's just the three of us in the program who manage the program for the province, plus our manager. So we're a really small but mighty team. We're a very, very, very busy program. And we do, unfortunately can't see that very well, but we screen applications, we test interpreters, we train interpreters, we deal with quality assurance on a regular basis, and as I mentioned, we also deal with a lot of province-wide policy and program development. So the Ministry of the Attorney General, we have what's called a registry of accredited freelance court interpreters, and I know that there are a number of you in this room who belong to that registry. So it contains over 700 court interpreters who provide interpretation in over 100 spoken languages. So we, about 100, there's more than 100, and we are always hoping that that number of languages will grow. The registry is for the exclusive use of the ministry and also for the municipal courts, and we consider it very highly confidential. On a regular basis, we get requests for access to our registry. Can I just get the list of Mandarin interpreters? Can I just get the list of interpreter's name? We never give out that information. It's highly confidential. Excuse me. In addition to freelance interpreters, the government also, the ministry also has a number of staff interpreters that work in the province, and my unit doesn't deal with the staff interpreters themselves, but there's about 30 in the province, and the majority are in Toronto, some are in Brampton, but these staff interpreters represent the more high-demand languages used in the court, so Mandarin, French, Spanish, Tamil, Punjabi, Urdu. Okay, now I'm going to speak a little bit about the testing. I wanted to mention as well, just very quickly, that because I know in this room we have both interpreters and translators. So the Ministry of the Attorney General, we only credit for oral interpretation and sight translation. Okay, so not for providing written translations. We don't know the world of translation. The world of translation is very different from interpreting. So we don't, our registry interpreters and our staff interpreters as well, they only provide the function of interpreting. Okay, so court interpreting is a highly skilled profession, and Ontario is a national leader in interpreting testing and training. The ministry created the court interpreting test back in 2009 in its ongoing efforts to improve the delivery of services to Ontario's courts. So they are considered to be amongst the highest standard in the world. Okay? They are court specific. Excuse me. They use real court transcripts. So it's very indicative of what interpreters can expect to hear in a real courtroom setting. Upon passing the test, interpreters of the ministry's registry are deemed to be highly qualified interpreters who have demonstrated their skills and abilities through this robust test. The ministry has 3 types of tests, and I'll quickly go through each one. So the first is a bilingual court interpreting test. Excuse me, I'm very sorry about that. Which we call, The government loves acronyms, so we acronymize, if that's the word, and make everything into acronyms, so we call it the BSIT. So the BSIT, this assesses the interpreter's ability to perform sight translation, consecutive interpreting, and simultaneous interpreting in the courtroom setting. So sight translation, interpreters are often asked to be interpreting for court forms, maybe victim impact statements. Consecutive interpreting is done with the witness on the witness stand. So when the witness is testifying, that the interpreter is consecutively providing the responses and then asking the questions to the witness in turn. Simultaneous interpreting would be usually with the accused. Okay, so the interpreter would sit closely right next to the accused individual, and the interpreter is whispering the entire proceedings to that accused. And as per section 14 of the charter, that's because the accused has to be deemed fully aware of their own legal process. The BSIT, so it's applied to the high demand languages in the province, and this is based on 2008 information, so these languages may have changed somewhat, but they're more or less the same. So some of these languages are, for example, Cantonese, French, Italian, Polish, Vietnamese, Tamil, and so on. So as a bilingual test, the candidate will hear both English and their other language on the test. They'll also receive documents in English and also in their other language on the test. So that's why it's called a bilingual test. The next test is the English Court Interpreting Test, the ESIT. So that's given to all the other 80 plus languages that we have on the registry. Okay, so they don't have an actual bilingual component. So it does assess the candidate's English language proficiency as well as their aptitude to perform sight translation, consecutive and simultaneous interpreting. Indirectly, it does assess their other language competency. And there is a very smart way that it's done on the test so that the other language is still used and the interpreter is performing consecutive interpreting between their languages. So examples of English languages that are tested under the ESIT, Amharic, Creole, Laotian, Burmese, Malayalam, and so on. The third test that we have is the First Nation Court Interpreting Test, the FN-SIT. Okay, this test is very similar to the English test, and I will be speaking more about the First Nation Interpreter Program in more detail in a moment. So before being tested, the ministry provides what's called their test preparation sessions. They are free of charge to all interpreter applicants who have successfully passed the screening process and have been selected for testing. We do receive a very high number of applications regularly, and only a handful are deemed qualified in order to take the test. The preparation class is mandatory for the applicants, and it builds on the test preparation material that we actually have available online, and provides helpful information on how to best use that material and how to practice for the test. During this session, a lot of valuable information and insight is given to the applicants in order to help them develop a familiarity with the courts, because a number of them don't have any, they've never stepped foot in a courtroom. As one colleague of mine used to say, no one goes to court for a tea party, right? So courts can be very intimidating, can be a very intimidating environment, and it is right from the start during this test preparation session that the ministry helps new applicants to understand how courts work, what to expect in court, and to understand their potential role as a court interpreter. There's also other helpful resource material that is given during this preparation class, such as lists of common court terms, court forms that are commonly used, and online links to language glossaries as well. So the ministry has an accreditation model of 2 levels that helps determine, these levels help determine an interpreter's strengths, but at the same time identifies areas for skills advancement. Interpreters under this model are scheduled to matters that typically best match their skills. So we have the accredited level on the left at the screen. This is where interpreters have achieved a score of at least 70% in each section of the court interpreting test. And this is for all 3 tests, it's the same. They can be scheduled for all types of court matters, particularly complex matters like trials and preliminary hearings. Interpreters at the conditionally accredited level achieve a score of at least 50% on every section of the test. They are typically scheduled for less complex matters that are shorter, but they could still also be scheduled for trials and other complex matters as well. There is a requirement that conditionally accredited interpreters work toward full accreditation by retaking the test, and the ministry guides them with useful resources on how they can improve their skills. Okay, so once an interpreter has passed the ministry's test, they must complete a 2-day training session before being added to the ministry's registry. During this session, in-depth discussions are held on courtroom procedures and interpreter ethics. Court observation is also performed at a local courthouse, and mock trials are held in class. Included in the discussion on ethics is a review of the ministry's rules of professional conduct for court interpreters. All ministry interpreters are bound by these rules. The rules outline the ministry's expectations of accredited court interpreters by clearly setting out the standards against which the performance as an interpreter is measured. Adhering to these rules helps interpreters to resolve difficulties that may arise in and out of the courtroom, and also serves to protect them and all parties involved in the proceeding. So we have 9 rules, the first being about quality, and all the other 8 are dealing with conduct. Quality, we call that our golden rule, where it's all about accuracy of the message. The other 8 about conduct, for example, that interpreter shall never give legal advice, shall never explain anything, simplify, add or omit information, explain anything even if they know what the answer is. And I've heard from interpreters that it's mind-boggling sometimes what people ask them, like, how easy is this judge? You know, should I plead guilty? How should I plead? They're asking interpreters this. And these are interpreters that have been with us for 10, 15, 20 years, and every person that they interpret for is new. And new to interpreting, they may not know, they usually don't know the role of the court interpreter. So it's really the interpreter's job to make sure that they are firm with their role and stating in advance what their role is. Okay. Oh, sorry, I'm not done the slide yet. Another important aspect of quality assurance that the ministry has in place is the complaints process, in order to ensure the highest quality of interpretation and conduct from its interpreters. The ministry has a formal process in place to review and respond to these complaints about interpreters' performance. Through this procedure, interpreter complaints are reviewed in a consistent, fair, and timely manner, and provide the interpreter with an opportunity to respond to the issues raised. And I will say that in terms of the quality complaints that we've received in the past number of years, once a thorough investigation has been completed, a number of times it's often come back very favorable to the interpreter, that it is shown that they have been doing their job well as an interpreter. So I'll be speaking about another section of the Charter that's very important to the court interpreter program. Excuse me. And this is section 11B. It's called section 11B in the Charter. And it states that any person charged with an offense has the right to be tried within a reasonable time. So some of the court interpreters in the room, they may remember or are aware of what's called 11B applications. So the accused, maybe after a certain period of time, and of course they're guided by their legal counsel, they submit what's called an 11B application. So this is basically that they think that they're not being tried in a reasonable amount of time. So the Supreme Court has clarified that the period of unreasonable delay begins at the time the charge is laid. To be successful at an unreasonable delay motion, the accused must be able to demonstrate that the delay in getting to trial was not their fault. So now, last summer, July 2016, the Supreme Court of Canada, they came out with a decision that's called R versus Jordan. So this is the Jordan decision. Some of you may have read about it last year, a year ago in the papers. So this decision has a huge impact to the program. This decision rejected the framework traditionally used in 11B arguments. So instead of the 11B, they replaced it with the ceiling, so a prescribed ceiling of, and the ceiling is 18 months between the charge, between when the charges were laid, and the trial in a provincial court without a preliminary hearing, or 30 months to trial with a preliminary hearing. Okay, so they set actual timelines as to what is considered to be a reasonable time that an accused is to be tried. So this decision is monumental to the way our courts are now run. The decision has established that a delay longer than 18 months or 30 months from when a charge is laid to the trial's completion is presumptively unreasonable. So this extends to our court interpreters. Interpreters who may forget to appear in court for their assignment could ultimately contribute to or result in a Jordan application. Okay, so it's no longer 11B applications now, it would be a Jordan application. And this is huge, it's a huge impact. Any delay beyond the time outlined that is not justified would result in a stay of proceedings. A stay of proceedings, that simply means that the accused, they may never be prosecuted. Okay? And these are, we're talking about murder, first-degree murder trials, and so on. So this is part of the discussions in the 2-day training the ministry has with its interpreters. It emphasizes that because interpreters, you are your own boss, you need to make sure that you show up to their court assignment. It seems very basic and simple. It could be an honest mistake as well, especially considering that some court matters can be booked months in advance. So could you imagine that you're booked for a trial that's 2 months long and you're booked half a year in advance? That's a possibility, okay? But you forget about this booking and you make arrangements with your family to go away on vacation at the same time. And then the court matter comes up and Madam Interpreter's not there in court, okay? That's a worst case scenario. But you can just imagine the impacts that has with that court proceeding. Okay? So hence the importance of training interpreters and having them clearly understand their roles as well as the impact they make on the courts. I'm going to be speaking to you now about the ministry's efforts with the Indigenous Court Interpreter Program. I'm going to have to speak a little bit faster because I think my time is running out. So there are 30 First Nation interpreters currently on the ministry's registry that represent 6 First Nation languages in the northeast and northwest regions of Ontario, the northern parts of Ontario. So languages such as Cree, West Coast Monkey Cree, Ojibwe, Oji Cree. In terms of the Indigenous peoples, the ministry's registry currently only has interpreters representing the First Nations. So we do not have interpreters for Métis or for Inuit languages like Inuktitut. We don't have interpreters for that. So the test that we've developed is specific to the First Nations and peoples. That's why it's called the First Nation Court Interpreting Test. When the new test was developed, it was in consultation with First Nation ministry staff, First Nation elders, the judiciary from the northern regions. The test was developed with the understanding of the unique working conditions experienced by First Nation interpreters. So for example, they do not perform simultaneous interpreting. The ministry has been providing ongoing support to its First Nation interpreters over the last several years. There have been a number of workshops and training sessions held with all the First Nation interpreters from both regions. It's usually held in Thunder Bay as a central point. You can imagine the logistics involved with flying in all the interpreters into this location. These sessions provide an opportunity for interpreters to practice and get assistance from fellow, more experienced interpreters with developing their skills in a group setting. Feedback has always been very, very positive in these workshops. The ministry will continue to provide the support to our First Nation court interpreters professionally, including promoting First Nation involvement in the justice system and in ensuring high-quality interpretation services for the First Nation community. As previously mentioned, one of the ministry's provision of interpretation in the courts is with respect to visual language interpreting services. So visual language interpreting is a practice of deciphering communication using sign languages, such as using gestures, body language, facial expressions to convey meaning, or using equipment as well. So as I mentioned earlier, we offer or we provide anything that when it's requested, such as American Sign Language, LSQ, Langue des Signes Québécois, deaf interpreting, communication access, real-time translation. The AODA, the Accessibility for Ontarians with Disability Act, so the AODA, this became law in 2005. Government and businesses that provide services to people in Ontario are required to meet certain accessibility standards in areas such as customer service, So in addition to visual language interpretation services in court proceedings, the ministry also provides visual language interpretation at all court counters. So anywhere that an individual, if they are deafened, or hard of hearing, at the moment that they enter the court house, the premise, even in the hallway, if they need assistance, that the ministry is required by law to provide and to assist them. Okay. Over the past few years, the ministry has been working closely with the deafened and hard of hearing community, as well as various justice partners, to understand the needs of this community and to specifically address their needs as users of the court system. Over the past 3 years, there has been an increasing trend in the number of ASL and LSQ interpreter requests for Ontario court proceedings. And the ministry continues this great work towards ensuring that the increasing demands for these visual language interpretation services are met, and ensuring that high-quality services are available to the deafened, and hard-of-hearing users of Ontario's court. Okay, so this is one of my last slides. And this is about an important decision that has a direct impact on our court interpreters. So, R versus Tran from 1994, this was a court case in the early 1990s. The case stemmed originally from Nova Scotia, where an accused required the use of an interpreter, and it was a Vietnamese interpreter that was used. For the defendant, they were found guilty, and defense lodged an appeal based on of the conviction, based on the argument, part of the argument. I think there were 3 layers of it, and one of the layers was that the interpreter had not interpreted everything properly, that everything had not been interpreted. So this appeal went all the way up to the Supreme Court of Canada, and at the time, it was the first time interpretation was addressed by the Supreme Court, and I think it may be still the only time that's been addressed. So Supreme Court of Canada is, of course, the highest court in all of Canada. R versus Tran is the decision made by the Supreme Court in 1994, and the decision refers to the Charter Rights, Section 14, that I already discussed at the beginning. So following the hearing of this case, the appeal was granted, so the accused won. And it was unanimous, too. So a new trial was ordered for that individual. So however, this ruling is important for court interpreters as it clearly defines the constitutionally guaranteed standard of interpretation, which speaks about Section 14 of the Charter. So the ruling stated the following: while the standard of interpretation under Section 14 will be high, it should not be one of perfection. It can be defined by a reference to a number of criteria that include, and are not necessarily limited to, continuity, precision, impartiality, competency, and contemporaneousness. Okay, so this decision sets out what the court considers to be an appropriate standard for interpretation in criminal proceedings. So the interpreter is not expected to, under Section 14 of the Charter, to be perfect. However, you're expected to be competent, per R versus Tran. The Tran decision cautions that interpreted evidence should not be examined microscopically for inconsistencies. Even the best interpretation is not perfect, in that the interpreter can never convey the evidence with a sense and nuance identical to the original speech. I should also point out that in this decision, the Supreme Court also stated that the quality of interpretation must not be so high that the defendant is actually more informed than those who speak the court's language. Because as we know, it is not the role of the interpreter to explain or simplify the language. Okay, the interpreter is simply the mouthpiece, the mirror of the speaker. This decision is now used as case law in trials where a ministry-accredited interpreter may not be available for requested language. The argument can be made that the accused is not by right entitled to a ministry-accredited interpreter, but rather to a competent interpreter, as per R versus Tran. And so competency of a non-ministry interpreter can be determined through a special court process, and ultimately the matter is not thrown out simply because of a lack of an interpreter. So some people confuse Section 14. We absolutely need a ministry-accredited interpreter. Well, we will obviously work towards that. That is always the highest that we will achieve. But it may be, we may have interpreters, but they simply may not be available. In that case, instead of having that case collapse, because that is always the worst case scenario, then the Crown can use the argument versus with RV Tran that, well, what's really required is a competent interpreter. Let's get an agency interpreter, come in, have them go through a special court process to be deemed qualified. Okay? So that ensures that that court proceeding will still happen, will still occur. So the Ministry's Court Services Division Court Interpretation Unit is committed to providing highly skilled and accredited freelance interpreters to Ontario's court system. If you'd like more information about the Ministry's Court Interpreter Program, please feel free to contact my unit at any of the following modes. Visit the Ministry's public website for more information. We're always welcome to receive an interpreter applications from all languages. Occasionally, we do focus our efforts on some languages more than others, depending on the needs of the court. For example, we are currently looking for qualified interpreters in Amharic, Cambodian, Creole, Maltese, Tigrinya, Vietnamese. There are others as well. It's, out in the east, in the Ottawa area, we're looking for more Arabic, Cantonese, Mandarin, Somali, Vietnamese interpreters as well. So if you know your friends, colleagues out in that area, please have them reach out to us. Anyone interested in applying, or if you know someone who might be interested, welcome to visit our website and contact us. A Ministry Freelance Court Interpreter plays an important role in ensuring access to justice in this very rewarding profession. So I thank you very much for your time today.
So you have been maybe time for 2 questions. There are 2 minutes.
Okay. And does anybody have any questions? Yes.
Yeah, I do have a quick question. What is the consideration behind the decision that you would like to keep the qualified registry of the interpreter confidential? Because they have been promoting the business, saying we are certified by MAP. So
Okay.
what is the consideration
Yeah.
behind the decision?
Okay, so there's a few reasons. So first of all, I mean, the ministry, we're not in the business of doing this for the benefit of other agencies, but we do, there's a lot of confidential personal information, of course, contact information of the interpreters. We understand both sides of it, though, because we still want to help out our interpreters. We know that they're freelance interpreters. So we just don't give out the registry, the list. But what we do is we act as the middle person. So if there is an agency, or it could be the OPP, legal aid, a law firm for examination for discoveries, we don't turn those down. So we still act as the middle person. And what we do is we connect them to interpreters. So we will reach out to the interpreters and we will say, this agency, non-court matter, they are requiring a Mandarin interpreter, and these are the details of it, and so we connect them that way. So no, absolutely, we still understand that as interpreters are freelance. So we try to help you to get work elsewhere. We've had interpreters even go to across country, to BC or to PEI for other assignments that have come through to us. Okay. Hi, Marion.
Yeah, I have a question following Jason's question. If there's a dispute between 2 persons, like person A is saying, oh, Jane Doe is accredited MAC interpreter, and John Doe say, no, he isn't. So can people just write to the ministry and inquire so that you can verify whether Jane Doe is MAC accredited? And also, there are people who are not accredited and they advertise themselves as accredited, or there are people who are conditionally accredited and they put on LinkedIn saying they are accredited, and that creates confusion. So if people or company writes to MAC, can MAC verify such person is or is not?
Our main concern is in the courts. And the courts and court staff that are booking, they know, of course, it's on the registry, the interpreter's level of accreditation. So they are aware, they know, the courts would be aware as well, whether the individual is deemed fully accredited or conditionally accredited. That's really our concern, and it can be proven. And if they require that information, if there's any question, if there's any doubt about it, then we can provide extra information. As to elsewhere, I can't really speak to that, how people promote their services or run their businesses as freelancers. But I just can speak to that within court, that's where concern lies, and that we do have procedures in place to make sure that all court parties are aware of an interpreter's level. Okay.
I think you have one last question, Anne.
Oh, hello. So, Andre Moreau, thanks for your presentation. Because of the subject matter dealt with by court interpreters, sometimes domestic violence, child abuse, interpreters run the risk of trauma. Does the ministry help with that?
That's a very good question. So, as I mentioned, we offer the test preparation sessions. So right from the beginning, we give the information of the serious nature of courts, and that courts can be very difficult. So right from the start, we emphasize the importance of self-care with interpreters and becoming more familiar for those that have never stepped foot in a courtroom, that they need to be doing lots of court observation. And absolutely, and this is discussed more at length during the two-day training. And absolutely, in the two-day training is a very good opportunity for interpreters to share their experiences. In terms of afterwards, at this point, the ministry does not have an actual program for interpreters for dealing with difficult content. Like I said, we do talk a lot about self-care. We do offer other resources. Certainly we are available if interpreters were wanting to discuss with us certain difficulties. We do encourage, we know that I've trained a lot of interpreters across the province, and what I always see is that interpreters there's a great sense of camaraderie, so I really pursue or have the interpreters work with themselves because they know themselves what's best in that environment and how to be dealing in those situations. So those are the things that we have in place right now.